May I please?
Yes.
Originally, arrest
Original 5 tarik first arrest.
in this case, this petitioner, he was originally arrested on 22/2/2025.
22
2 2000.
Why originally means 2 cases are there? Oh,
There are
it's a
lots
case
of
of shown arrest also.
This is shown arrest, in the first case, he was arrested in 22/2025. And there's one more case on the same day. Again, he was arrested in same day. That is also in 22/2/2025. That is in Patharkandi. One first case was a 54 of 2025. Second was 55 of 2025. Patharkandi police station.
Both are from Patharkandi police station.
In the original 2 cases, Patharkandi police station. In the first case, the bail was granted on 3/3/25. That is the page number 87. 31. Page number 31. Bail was granted by this honorable court as there is no compliance of 4750. And the second case, which was shown arrest in the Patharkandi, that case also we have moved before this honorable court, and the bail was also granted in that case on 11/3/2025. This case is very important to adjudicate this particular case. In all the cases, there is a similar kind of affairs. I'll come to the FIR, all the cases. Now, Lordship, kindly turn to the second case, second FIR, registered in Patharkandi. Page 29.
29. This is the FIR of second FIR.
This is the second FIR. First FIR also content is same, but I'm coming to the second FIR, which is more elaborate. Page 29. With reference to the subject cited above, I have honor to draw your kind attention to the law and order situation that did arise at the Central Public School, CPS Patharkandi, on 21st October 2025, after the conclusion of the second 12th standard examination. The CPS is the CBS affiliated school providing education up to 12th standard. The school is promoted by Educational and Research Development Foundation, ERDF, based at Gauhati. The foundation also ran a private university named University of Science and Technology, Meghalaya, shortly USTM. The Center for 12th Standard CBSE examination students, the CPS Patharkandi and the nearby Adarsha Vidyalaya, Dwarpara, were allowed there. The 1st February 2025, the physics paper, total 275 numbers of students appeared for the examination. Out of 275 numbers of students, 15 numbers were from the nearby Adarsha Vidyalaya, and 45 numbers of students were regular students of the Central Public School, and the remaining 240 numbers of students who were enrolled in Vision 50 under ERDF. It is pertinent to mention here that the students of Adarsha Vidyalaya, Loyalpara, and the regular students of the Central Public School did not partake the protest. The law and order situation was mainly caused by the remaining 214 numbers of students who were not part of the regular classes in the Central Public School at Patharkandi. All the students are mostly juvenile. Their protest was carefully handled by their grievances as headed. These students alleged that they belong to the different parts of Assam and had come there to appear exam. They were promised by the school authority, Lachikani Mark, the school authority, that they would help the students in passing as well as enhancing marks by adopting the unfair means. Few students also alleged that they were demanded monetary gratification by the authority to help them to pass the examination. To our surprise, it is found that 214 numbers of students never did any class in the CPS Patharkandi. They came here only for the 12th standard examination, and it was promised to them by the authority that it was their own center and it will be smooth and convenient for the exam. Them out in the flying colors and adopting the unfair means. These 240 numbers of students were doing coaching classes at USTM campus under the aegis of the Vision 50 project and entrance into the medical and engineering examination. Many of them did not even know that they were enrolled in CPS Patharkandi. They were kept in dark by the authority, as well as some of the students are transferred from the Vision 50 Gauhati by means of deception with the promise to help the forthcoming exam. These students have created law and order situation when did not find any assistance. Now, logically market, these students created the law and order situation when they did not find the assistance forthcoming, which was promised by them by the authority. So when authority did not allow them to cheat in the examination, so then they have protested that we are not allowed to cheat in the examination. That is the crux of the first information, the first FIR also, that the authority did not allow to take any unfair means. That is the grievance of the students, and because of the authority did not allow, so this is the case, madam. Apart from the few students also alleged they have been promised by the USTM authority to clear them out in GE-NET examination conducted by NET to get the prestigious medical engineering colleges and with quick pro basis against the money. It is also safely suspected they will also facilitate unfair means in the clear competitive examination related to various jobs. Therefore, it seems it is a case of massive criminal conspiracy having large sinister design. USTM authority by the Mahbubul Hoque, who is the petitioner before Lordship, has been a part cheating the student by making the false promise to them, criminal breach of trust, and the forgery. However, they have been part of organized crime by facilitating mark cheating in the examination. They have jeopardized the sanctity of the examination. Part of many students also they have requested register so and so, so and so, so and so. So this is the content of the FIR, and this is a detailed FIR related to the first FIR. Little bit of short, my lord, but this is an FIR which covers everything. Also alleges there is a larger conspiracy involved in this case. So this is the second FIR, and this FIR also is filed by the circle officer and the executive magistrate, Patharkandi Revenue Circle, where the incident took place, the cause of action arises, madam. So it covers all the students, the 214 numbers of students, their involvement in this particular FIR, madam. Now, we have challenged this FIR, my lord, and the bail was granted. But before that bail, my lord, Lordship can see the affidavit filed in this case by the state, that Lordship will find page 59, 52, and 59.
One by the Home and Political Department, one by the IO.
This is very important, that 52 and the 59.
These affidavits are filed by the state.
Affidavit filed by the state in that second case during the hearing of the bail petition, my lord.
The 58 to
52, my lord. The first affidavit submitted by the additional secretary to the government of Assam, Home and Political Department, my lord. The first affidavit in bail application so and so. In the paragraph 1, 2, and 3, my lord, basically the allegation in the FIR itself. 4 also the same FIR contents of the FIR. Now 5 onwards, my lord, important. That the accused person, namely the Mahbubul Hoque, the chancellor of USTM, Numan Ahmed so and so, were arrested in connection with the Patharkandi PS case number 54, my lord. That is the first case, my lord. 54 is the first case, my lord. And were subsequently shown arrest in the case number 55. This is the based on the substantial material evidence indicating their involvement in the commission of the alleged offences, it is pertinent to note that the Patharkandi PS case number 54 of 2025 was registered on 21/2/2025 at 10 p.m. and the GD entry was also made in so and so at the time, same date, and uploaded in the crime and criminal tracking network system so and so at 47 IST. To clarity, Patharkandi PS case number 55 was also registered on 22/2/25 at 10:30 a.m. and subsequently uploaded at so and so time. The difference between the time registration of the time uploaded in CNC is solely due to the server-related procedure. The custodial interrogation of the accused person is essential to trace the financial transaction and linked with the collection of the illegal payments from the students, recover crucial records and digital evidence in their possession, and that their association investigate alleged nexus between the accused and the CBSE officials concerning the allocation of the examination centers, and the record further statement of the students who has disclosed incriminating details about the promise made by the accused in facilitating unfair means. That the accused person was highly influential individual with substantial political institution backing, making them threat to the integrity of the investigation. It has come to the light that the certain political figure and the high-profile individual have visited the accused person while he is in custody, raising concern of potential witness tampering. That the statements of aggrieved students recorded so and so have provided damning evidence about their formal statements so and so. That the accused person have not cooperated with the investigation, has although deliberately evaded key question during the police interrogation. That the premature release of the accused person on bail would severely prejudice the ongoing investigation, would like to lead the tampering of digital and financial evidence, including the online transaction and electronic communication, intimidation of the witnesses, complainants, particularly students who have testified against the accused, and the destruction of official records relating to the fraudulent admission and examination malpractices. Now, paragraph 11 is not important. That the counsel of the petitioner has relied on the judgment of Dhanraj Ashwini so and so, reported in, however, the said judgment. So, in this case, what happened, my lord? It was a case of a shown arrest, my lord. So, we raise the question that in the case of shown arrest also, that the 47 and the 48 also needs to be complied with. There is no leeway to bypass the 47 and 50. Earlier 50, my lord. So that was our primary ground, because in that the second case, the no grounds of arrest was communicated to me. And 48, 47, they have bypassed, because the contention of the state was that in a shown arrest case, it is not required. But the Supreme Court, we relied on the judgment of the Supreme Court. So basically what you will find in this case, apart from the first case, that is the 54, there is no mention about any other case at that relevant point of time when it was filed. And this is date is what you can see. The date of this affidavit is 7/3, page 58, 7th day of March 25, my lord, page 58. There's a one more affidavit, my lord, the next page, 59. This is by the IO of that particular case, my lord. In this case also, my lord, he has elaborately discussed about the materials, but the objection and the merits in both the affidavits are same. But in the second affidavit by the IO also, apart from the first case, there is no whisper about any pendency of any case against the petitioner, madam. This is also on the same day. The affidavit was shown on, that is on 7th of March 2025, madam. Then the bail was granted to me in this case. That lordship will find order of the second,
41.
that is page 41, my lord. So accordingly, bail was granted to me. In the meantime, there are some more FIRs has been initiated against this petitioner, my lord. That is one at my lord Hoque PS case number 31, that is in page 75. Then the one at the Kokrajhar PS case number 61, that is page in 81. Then one is Borpeta PS 72, that is also page in 787. All these three FIRs in these cases, my lord, this Honorable High Court given interim relief with a direction that no coercive action shall be taken against the petitioner, my lord. All these in, and these are all similar kind of FIR, my lord. But the second, as I have already shown, that was the most elaborate FIR, my lord, the second FIR. And these are also, these three FIRs also filed by some of the fathers, some of the relatives of the students, some of these organization, but these are there's a direction by the Honorable High Court not to take any coercive action till end of this month, my lord. The next date is fixed on 28th of this month, my lord. All these order I have annexed, my lord, regarding the no coercive action
in these three cases.
In these three cases, my lord. Now what happened, my lord? Now what happened, my lord? When I was already granted bail, then I have been again shown arrest in this particular case that has been registered at Thekiajuli, PS case number 55 of 2025, my lord. Now, the most stunning factor of this case is that this case was registered, that is on 24/2/2025, my lord.
Case was registered.
Case was registered 24/2/2025, and the affidavit they have shown in, that is on 7 March 2025. That is in the February, March. And these are all FIRs registered in the month of February. So when this particular two FIR was filed before this Honorable Court, affidavit was filed, this particular case was already registered at the relevant particular police station at Gauhati. But surprisingly, the authority, the state or the IO in that particular case is absolutely silent regarding the existence of this particular FIR, which has been registered at Gauhati at that relevant point of time. And that information was not given to the court, that there's one more case has been registered against this petitioner and which is pending for investigation. That FIR was not, that information was not supplied to the court nor to the petitioner here. So this is an absolute violation of the mandatory provision of the Constitution of the India. Now, coming to next, now the lordship kindly see the FIR in this case, my lord, at page 98. Page 98, lordship kindly see the first information received at Patharkandi, Thekiajuli, date is 24/2/2025. Mark the date, my lord. Date is 24/2/2025. As I said, that this is prior to the filing of the two affidavit before this Honorable Court. Then the number 5, point number 5, place of occurrence, direction distance, that is Thekiajuli. Place of occurrence is Thekiajuli. Now this, admittedly in the first FIR, in the second FIR also, that the whole place of occurrence, that the students' agitation, whatever may be, that is had happened with Patharkandi. And they were taken admissions, admittedly, also at USTM, it's Meghalaya, Rivoi district. No way connected.
They appeared exam from Patharkandi.
Patharkandi, yeah,
But
Patharkandi.
they were the students of USTM.
USTM.
For their convenience, it was.
That is the allegation, my lord. So that these are the students of USTM, but without going with the regular classes, they are appearing examination in the Patharkandi. That is their allegation, basically. But whatever, my lord, what has happened, my lord, whatever, let us assume something had happened in you. Everything had happened in Patharkandi, admittedly. And the or in the Rivoi district and USTM. Nothing, no cause of action at the Thekiajuli, my lord. But instead of that, the case was registered in Thekiajuli.
How on the basis of the
FIR lost by the father now.
father?
One of the, that 214 students, regarding that the second FIR,
Yes.
out of that 214 students, one father has lost this FIR, that is will lordship page, the relevant portion as page 100. How he is aggrieved, my lord. Myself, Sri Muksed Ali, 60, so and so, Thekiajuli, Sunitpur is a farmer by the profession. My son, Sri Farid Ali, students of class 12, USTM, University Science and Technology, Meghalaya, and appearing in HS exam He was also undergoing classes at USTM campus under aegis of Vision 50 project for the entrance in the medical and engineering colleges. I gave admission in my college at USTM with a dream of bright future of my son at the study center. That said, the USTM authority, by inducing my son and many of his colleagues, traffic them and enroll them in the CPS Central Public School at Patharkandi to appear in the HS final examination there. As per information received from the some public, it is learned that the CPS Patharkandi and USTM both are under the same foundation and Educational Research and Development Foundation based on Gauhati. The USTM authority took the whole amount of 5 lakh in the name of coaching with the guaranteed admission of my son in the any need. Just before this ongoing final examination, my son paid 40,000 to the USTM authority. So whatever may be the allegation, this is the son has taken the admission at the USTM, that is in Meghalaya, and he has appeared in the examination that is in the Patharkandi. So the whole cause of action apparently on the face of the record, either in the USTM at Meghalaya or in the Patharkandi. No cause of action, absolutely he is silent about any cause of action in the Punitpur district. Now this case has also been registered under 3184, 3185, 3363 BNSS read with 11(1) of the Public Examination Promotion and Unfair Means. But in this particular act, the requirement of that if there's an investigation pertaining to this particular special act, there's an procedure has been laid down and the officer has been specified who can investigate these offenses, that is 12. Section 12. The officer empowered to investigate. An officer not below the rank of the Deputy Superintendent of Police or the Assistant Commissioner of Police shall investigate any offences under this act. Now, let us come to my lord, our FIR. This to investigate this FIR. It was entrustment was given to one Sub Inspector Deepak Talukdar. Inspector of Police, my lord. Deepak and the my lord, the page 99, Lordship will find.
Deepak Das or
Deepak Talukdar, sorry. Deepak Talukdar, page 99. Lordship will find the last paragraph. Name of the IO, Deepak Talukdar, rank SI of the police. Deepak Das is the OC, my lord.
Okay.
Deepak Talukdar is the SI who has given the power to investigate this. But as far as the act is concerned, my lord, only the DSP or Assistant Commissioner, they can only investigate the case, my lord. So apparently, when case was investigated, it was by the Sub Inspector in this particular case, my lord, apparently. So in some of the cases, all cases, my lord, the same procedure was followed. So what High Court has observed, my lord, in this connection, my lord, there is some observation in the some of the stay order while granting the state order, page 92, my lord. They can change the investigating authority later on. That's not the issue, my lord. But they have to take the prior permission of the concerned court to change the IO, my lord. Internal communication, changing the IO will not do. That is the observation, page 92, my lord. And that was considered by the learned public prosecutor, Assam, very fairly also.
He submitted that the case was re-endorsed to
Yes.
SDPO subsequently.
Yes. But he has also admitted that without prior permission, my lord. Page 92. Page 92, my lord. That is our contention, and he has considered to that fact, my lord. Page 92.
This is in connection with which case?
This is in connection with, my lord, Borpeta PS case, my lord.
The second or third FIR.
Subsequent FIR, all 3 subsequent FIR, my lord. That is one Gauhati, one Kokrajar in Borpeta, similar kind of FIR, and the similar orders in all 3 cases, while protecting the this page 93, lordship can see the last paragraph. The proceeding paragraph also, Mr. Bora has submitted that the FIR was registered by an inspector of police and it was endorsed to Sub Inspector of Police. Accordingly, Mr. Bora, in section 12 of the Public Act, has been prescribed in the officer not below the rank of the Deputy Superintendent of Police or the Assistant Commissioner of Police shall investigate the offence under the Act. Today, Mr. Fukan has submitted that case has been re-endorsed to the Subdivision as Police Officer so-and-so to investigate. To that effect, Mr. Bora submitted that the change of the investigating officer should be intimated to the Eleka magistrate, and without intimation to the Eleka magistrate, investigating officer cannot be changed, and this is the law which Mr. Fukan also agreed. So the public prosecutor fairly agreed the proposition, my lord, that without the prior permission from the court, there cannot be change of any investigating officer. So considering all these things, my lord, that these all 3 FIR, Gauhati, Kokrajar, and Borpeta, the same procedure was followed. So this court has stayed the arrest of this petitioner in these all 3 cases. But His arrest was obviously mandatory for some people. So this is the sixth FIR before your lordship now. Now in the sixth FIR also, as a lordship instructor, that this was also endorsed when sub-inspector, which is not permissible under the law, madam. He cannot investigate this offense, madam. But he has investigated. He has also gone and arrested. Now, subsequently, it was handed over to the DSP without the prior permission of the court, madam. That is our contention that they have changed it subsequently because of these orders, my lord. Subsequently, they have changed it, but they did not took the permission leave of this LACA magistrate for the purpose of investigation. Now, also, lordship has seen that this FIR has been registered at Hoque, and this is the sixth FIR. And I'll say this is, though it is the sixth FIR, it is a outcome of the first or second FIR itself. So basically, it's a second FIR, as far as which we used to say. If there is one more FIR for the same cause of action, there cannot be the second FIR. That's the settled proposition of the law. And coincidentally, the second FIR lodged in this case, that is in the Patharkandi 55, this was elaborately, it has covered everything, madam. And in their affidavit also, they have elaborately everything. They've said that there's a larger conspiracy involved. The students needs to be interrogated. Everything they have elaborately said. So from that FIR itself, that the Patharkandi 55, everything is covered regarding this alleged offense, madam. Everything is covered. If everything is covered, whether these subsequent FIR, this subsequent FIR can be investigated at all. That is my first contention. That it cannot be the FIR. It can be only be in 161 statement in connection, maybe in connection with that Patharkandi 55, my lord. This FIR absolutely, my lord, non-est in the eye of law, because the content of the FIR is already covered by that FIR itself. And the investigating authority also, he is also not has the power. Now, before coming back to the legal proposition, my lord, there is one more development in this case that is also very vital to decide this case. That is the one affidavit filed by the informant in this case when this petitioner was produced before the magistrate court, my lord, during the product. That is page 107, my lord. He appeared himself and he filed an affidavit to the court.
The father, I think.
Father.
The informant.
The informant and the father of the.
Sorry.
He has said, my lord, page 108, my lord. I am the informant of the so-and-so. That's on the basis of this coercion. Now, lordship can mark it. On the basis of the coercion, undue influence by police personnel and the other authorities resulting in some misconception, I lost the aforesaid FIR Hoque PS case number 55 on 24/2/2025, wherein I have erroneously brought about the allegation against the Mahbubul Hoque and other USTM Vision so-and-so project personnel, and also alleged that my son was trafficked and enrolled in the Central Public School, Patharkandi, amongst the other allegations as directed by the authorities. That I had lost the FIR under pressure and the undue influence. And now, after understanding all the material facts clearly, I hereby state that the Mahbubul Hoque and the USTM Vision for the so-and-so Patharkandi, the persons are not involved in any offense as alleged in the FIR. That after passing 10th board examination in the year 2023, my son, SK Farid Ali, was enrolled and appeared in the class 11-12 CBSE board examination from the Central Public School, Patharkandi, and I was aware of the same. Moreover, any payments which I have made were all only levied fees for the Central Public School, Patharkandi, and the Vision 50 coaching program, and nothing apart from that. No guarantee was provided to me for my son for clearing NEET and providing better marks in HS examination. That I have now realized my unintentional error, as such, we hereby declare that the Mahbubul Hoque so-and-so are in no manner connected in the so-and-so occasion. That I intended to settle the matter expressed in the actual considering the mistake on so-and-so FIR against the accused person. In view of that FIR was lodged as a result of so-and-so, I do not have any objection if the aforesaid case is terminated against the so-and-so or others. I also no objection if the Mahbubul Hoque person, other persons is granted bail in connection with the intense case so-and-so. So this is the FIR file. The first line, the affidavit of concern, on the basis of coercion and undue influence, this man was forced to file this FIR. He is absolutely, my lord, illiterate man, my lord. His signature appears to be, my lord, and the FIR was lodged in English. So, next one is the order of the magistrate, my lord, first day order, 113, my lord. He has discussed everything, my lord, but the case was later on fixed for another date, and subsequently bail was rejected. Bail was primarily rejected by the magistrate, my lord, only on the ground that is the early stage of investigation. That is the only ground. Though in the entire order sheet, lordship will find the whatever ground we have taken before your lordship, everything was also argued before the court, but it was not considered. Neither was distinguished simply because of the fact that Mahbubul Hoque is an influential person in the early stage of investigation, whereas, my lord, our High Court in all cases, all previous cases, he was granted bail. 2 cases he is granted bail. In 3 cases, his arrest was stayed, and the first case also bail was granted. So, and the second case affidavit also he has not considered, my lord, the learned trial court. His contention is that he cannot compound the offense. It is a non-compoundable offense. We are not on the compounding here, madam. We are only on the how this FIR has been initiated. The informant himself was influenced rather by the police authority concerned. And lordship can see this is the 6th FIR on the same facts. One after another FIR is going out in the all over the state, madam. And lordship can understand though I have been cited as an influential person, but who can be influential in this case?
11-3 I was granted bail. I would have been a free man. 11-3 only I was.
So, on 11-3, I was granted bail in the second case by the Honorable Court. On the same day, on 11-3, I was again picked up, shown arrest in this particular case, which was not earlier disclosed by the state that this was pending. So that point is enough to settle, apart from the second FIR. So coming back to the legal issues involved, now, if the information regarding the pendency of any case during the bail hearing is not communicated to the court, what is the effect? That is in the Supreme Court says, if that is be so, this man should be considered as free man. That is the language of this court, the Supreme Court, as well as our High Court by the Honorable Justice Ujjal's judgment, my lord. And probably your lordship also dealt with the one matter in the particular case, my lord, the similar situation. So first, my lord, before going to the Uday Chand, my lord, this is a very short paragraph, my lord. In the Uday Chand, my lord, paragraph 5. In the Uday Chand case.
Yes.
Paragraph 5. Mr. Sketcher stated before us that the petitioner were enlarged on bail in pursuance of the order passed by the court on March 2, 1981, but they were subsequently arrested for some other offences alleged to have been committed by them prior to March 2, 1981. We are quite amazed at this statement that we should have expected that if, after order of the bail passed by us, the authorities of the state considered it fit to arrest any of the petitioners for any other offences, it was their bounden duty to apprise this court before taking this person in custody, especially when no disclosure was made to us when we passed the order of bail that any case or cases were under the investigation against any of the petitioner. We regret that this elementary courtesy to this court was not shown, madam. Lordship, kindly mark the words, madam, because we are here for the establishment of the rule of law, madam. We would like to reiterate that the petitioner shall be treated as free citizen, madam. How the court has, that is in, my lord, 1983, and now we are still in 1924. Still, we have to follow the same agony from 83 to 24, my lord. Still, they are doing the same thing without informing. Person is arrested, re-arrested, shown arrested, not informing the court. How many years, my lord, has been passed? So many water has flown down the river, but we are incorrigible, my lord. Now, the Kamal Datta, this court has observed.
This was passed in 2016.
Madam?
Justice Ujjal's order.
Yes, 2016, my lord. Reported 2016, 1 GLT, GLR, passed in 5. Passed in 5/11/2015.
Sorry, 511.
Page number, lordship will find page 543. The President G. The similar situation in this case also. Secondly, when this court has a lordship got it, the
Yes.
President G. Secondly, when this court has granted bail in Pasigat PS case in 56/14, this court was not informed that the accused was also wanted in Basar PS case 9/14 and Itanagar PS case /304/13. Even the learned judicial magistrate first class Pasigar, who has passed the consequential order 1912-2014 following the bail order of this court, was not informed that the Tapan Datta was wanted in those cases where he is an accused. Not even the High Court, not even to the magistrate courts also, my lord. Here also similar situation, my lord. I was granted by the lower court when the bail was granted. It was not also placed. It was stated in affidavit that Tapan Datta was arrested by Pasighat police on requisition of the Basar police from outside of the court on 19/11/14 at about 4 p.m. He was handed over to Basar police station on 20/11/14, whose turn produced in the accused before the magistrate on 21/11/14, which again beyond 24 hours arrest and so arresting the accused in a different cases from the outside the court where he was granted bail without disclosing the court about the need to arrest him in another case is wholly unacceptable. When, my lord, this case was hearing was going on in the item the 55, my lord, they filed the affidavit, two affidavit, not only one, and that by the home. And they were absolutely silent that the one more case is pending. And they took a 7 days time to file this affidavit. From the first date when the hearing took place, they took 7 days time to file the affidavit. Even then, the case was long before it. That was registered in 24 itself. And the affidavit filed in 7th of March. Case was filed in 24th of the February. They were absolutely silent regarding the pendency of this particular case, madam. Why? Because they're waiting that the moment I'll got the bail in one case, they'll arrest me in the another case. So they're waiting for that, so that I can be deprived of taking the legal recourses, madam. I could have come before this honorable for anticipatory bail or no coercive measures in that case also. So they have suppressed it intentionally, not to me, even to the court also, madam. That's the very biggest, madam, concern for us, madam. How they can do it, madam? The only purpose to defeat the justice, madam. They're playing with the justice, judicial whole system, madam. Apparently, what prompted? Why they have not filed in the affidavit that the one more case is pending? If I am so much, they can write everything about me, madam. I'm a habitual offender. They're saying I'm doing the conspiracy, but they're not disclosing. And they are in this case also they have registered what, madam? The case under special act.
But this case is also from the that 214 who appeared, and the allegation was there for unfair means or whatever. Same set of this FIR. His son was also appearing in that exam.
Yes, exam same. Because only 214 exams. He is out of that, one of them. Same exam, same students. Already case has been registered. Now this is a second case on the same fact. There cannot be a second FIR for the same case, madam. The TT Antony's case is, and this is the second FIR is an elaborate FIR. They themselves say that this is everything has been covered in the second FIR, madam. They cannot say that there's more, something is more yet to come, madam. They have elaborately everything has been disclosed in the second FIR itself. There cannot be the third one, madam. FIR for the same cause of action. If we take it as the third one, madam, where I've been arrested, madam. All 214 students is covered in this particular case. And then now only the individual has come. Only one individual. Tomorrow one more, maybe more. Now, in this case, madam. So relying on the Uday Chand's case, my lord, the paragraph. In the Uday Chand's versus so, the apex court has deprecated the practice of withholding the information from the court about the requirement of the arrest of the accused in other cases. It was held that if after order of bail is passed by the court and the authorities of the state is considered to fit to arrest a released person for any other offences, it was their abundant duty to apprise the court before taking such person in custody. In that fact, that the arrest was held to be contrary to the bail order passed by the apex court, and accordingly petitioner of this case was released from the custody, treating him to be a free citizen. Having regard to the above, the court is of the view that the accused Tapan Das should now be released as his continued to detention has become clearly untenable. As noticed above, he has been granted bail by this court in 1 out of 4 cases, that is Pasighat PS case number 56 of 2014. He shall now be released on bail in connection with the other 3 cases, namely Itanagar PS case number so-and-so, Basar PS case number so-and-so, Alo PS number so-and-so, subject to the condition that he shall cooperate with the investigation of the cases and that he shall also appear before this court on the next date. Since the finding has been recorded that is so-and-so, so-and-so. Accordingly, the last line of this paragraph, my lord, accordingly, Sri Tapan Datta can now walk out of this court as a free man. This is the language, my lord. And the next part is regarding the 50,000 has been granted to this Tapan Datta because of his illegal detention in the subsequent cases. That was dealt in the second part. But the first part, so the ratio of these cases is very clear, my lord, that if you want to rearrest me, you have to inform the court during the hearing of the bail application also on the previous time. So that information should come to the court, my lord. Here, this information is never given to the High Court. Even then, he was subsequently arrested, my lord. So this is speaking. The main paragraph in these cases regarding the second FIR, 14, 16, 20, 21, 32, and 47, my lord.
Yes, let's repeat again. 14.
14, 16,
Yes.
22, 20, 21, 32, and 47, my lord. So these are the ratio, but the 47, what you kindly, I'm reading 47. What was the observation made by the apex court when there is a second or the third FIR comes into for the same cause of action? It is further clarified that those persons who were arrested in connection with the CR case number so and so would not stand arrested in connection with the CR case number 154 of 2008. So there's a clear direction. They cannot be arrested in the second FIR. So the subsequent arrest, as per the Supreme Court, is in the second FIR is illegal, madam. They cannot be re-arrested in the subsequent same cause of action, madam. FIR for the subsequent same cause of action. They cannot be. That is the ratio of this case, madam. There are 9 and 10, your lordship, own judgment, madam. I'm relying on that also. So basically, that case, the lordship has relied on the Uday Chance case, madam, in this particular
Yes.
order, madam. So apart from Uday Chand, madam, our own High Court has elaborately discussed in Kamal Datta's case by the Justice Ujjwal Priya, madam, that he should be treated as free man. My case also similarly situated, madam. So I pray, madam, at that stage itself, considering on the prima facie record, he should be released on bail today itself by your lordship, madam. Without any, because any detention will be an illegal detention further, madam. Any detention further, madam. And this case is concerned, madam, and lordship has seen already that informant himself filed an affidavit that under coercion and threat, he was forced to lodge the FIR.
Yes.
So I'm not on the ground of the withdrawal of the cases at this stage, madam, regarding his, but for the purpose of bail, it has to be considered because the recent judgment, the lordship knows that every informant has the right, participatory right in a proceeding, even in the bail at every stage, madam. So that right has been given to the informant also. And when a right has been given, that right has to be executed, madam. Not it's just a formality. It may be either in favor or maybe in against, but it has to be addressed, madam. In the Jagjit Singh recent judgment, madam, the 24.2, the Rajasthan Supreme Court says that he has got a participatory right.
Yes, that is.
And if there is a participatory right, if the right is granted to a person, its right has to be executed, madam. It cannot be just a formality. Court must give a value to that particular right, why this right has been granted. And this case, the informant, he has come of his own, filed an affidavit that under threat and coercion, he was forced by the police to lodge the authority. And lordship can see that the reason for all these FIRs, one after another, in various places. What was the need for so many FIRs? Just to put me behind the bar? That to a chancellor of an university, madam. And he's also suffering from, I have given all the medical documents also annexed. So what was the requirement? And why they did not disclose it, madam? Why they have concealed the vital fact that one more case is pending? It is apparent that when the bail will be granted by this honorable court, and that has exactly same thing had happened, because on the same day when the bail was granted by this court, the same day he was taken to custody by the another police, madam. They were waiting there just for the bail order. The moment the bail order was passed on that day itself, not in the previous day also, or in the prior few days, because case was registered long before in 24. They could have arrested me in the 24, 25. I was in the custody in the Koringal. Everybody knows about it, that I was in custody. But no, they have waited for the passing of the bail order, or they might have also probably Ponjika Saya Habuli Kasa. Ponjika Saya is the right moment for the arrest of this particular person, madam.
It will help in the investigation.
Yes,
Right.
yes. So they might have waiting for that right moment. So this is my case, madam, basically. So I pray, madam, this is absolutely illegal detention of this man, madam. Apart from the legal flaws, apart from that, madam, that he's already considerable time he's in the custody from already a month has passed from the first arrest, madam. He was arrested in the first case in 22 itself, madam. And this case also, he's in custody 9 days, this case. So his further detention is absolutely not necessary. Apart from, my lord, considering all aspects, the legal aspect, the investigating officer, he doesn't have the power to investigate without the prior permission of the court. This is absolutely an FIR which is subsequent to the already existing FIR, second FIR which is honest in the eye of law. Then the non-informing the court, which is the biggest flaw in this case, that they should have complied it, and the non-compliance, it should come. I should be treated as a free citizen of India as per as the Supreme Court and our High Court says. He should be treated as non. In that case, he's not even allowed to go in bail. He's directly, he said that he's a free citizen. He can go from the court itself.
Yes.
And finally, informant himself has come before. And Lordship knows what will be the fate tomorrow regarding investigation. In this case, nothing.
Thus, I'll hear to you just for 5 minutes. Actually, for wrong doctor's advice, I'm just taking 5 minutes. Okay, just 5 minutes.
One of the good things about appearing in this kind of cases is one gets to learn a lot of law on these issues, my lord. So these are issues that, my lord, this comes up regularly, my lord. But in this case, the informant, my lord, is a farmer. He's a farmer, my lord, and his son was admitted in this Central Public School of Assam, where he had appeared for the examination. So, my lord, because of some misconception of fact, because when this entire investigation unraveled, my lord, a lot of people came to a lot of other students also, including the petitioner, the informant, my lord. Because of the entire surrounding confusion which came up because of this case, my lord, some misconceptions of fact happened, my lord, which led the informant to lodge this FIR, my lord. But the informant, my lord, has no objection if the petitioner is granted bail. So, my lord, I'm not opposing the bail application. There's a legal issues your lordship will examine. As far as I am concerned,
Well, what you want to say in regards to your, undue pressure was there on you?
this is an affidavit sworn before a notary, my lord. And this has been sworn on 13/3, my lord. And this was produced before the learned magistrate also when the bail application was moved. So I stand by the contents of the affidavit, and I don't oppose the bail application.
So,
Wait, Vijay Bachi. First, I take to meet the contention made by the petitioner in respect of the investigating officer, power of investigating officer. My lord, I beg to draw your lordship's attention to page 100. That is the FIR of this case, my lord. 100.
yes.
Your lordship may kindly see the endorsement that one report talukdar sub-inspector has been endorsed. And this endorsement was made on 24 to 25 itself, on the same day on which the case was registered. Obviously, this is an administrative order for the purpose of endorsing the case to a particular investigating officer. Yes, I understand. Per law, this is wrong. Now, that mistake is administrative order, your lordship know, but it is always curable. And there, from the order itself, your lordship may kindly come. The order referred to by my learned friend, case 93. Yes, it cannot be changed without informing the Elaka magistrate only. That means procedure has been prescribed for such change of the investigating officer. It is not that there is absolute bar. There is absolute bar that once case is endorsed, it cannot be changed. I cannot be changed. Now, I do not know whether thereafter any change has been made or not. And the petition itself is also silent. Whether any without magistrate's order, this IO has been changed or not. So, my lord, now I beg to draw your lordship's attention. My lord, may kindly come to paragraph, my lord, page 108. Actually, this starts from page 107. This is the, my lord, affidavit filed by the informant. Your lordship may kindly see paragraph 3. That on the basis of coercion, undue influence by police personnel, who is that police personnel is not revealed, and other authorities, who is that authority, not revealed, resulting in some misconceptions, I lost the aforesaid FIR. See the nexus between informant and petitioner. That is why, my lord, that is why the result of case diary, relevant case diary, is necessary in this case. But you have seen the situation. The informant very first they comes and say, I do not oppose. This today it is first thing. It has been listed for motion. And on the motion itself, the informant engages a lawyer to intimate the court that he has no objection if bail is granted. After coming out from bail, on bail, my lord, your lordship will see what will happen to the case. Now he is in jail, and from jail itself, he could influence the informant. Entire case will go.
He's in your custody.
Entire case will go, my lord, if he is released on the bail today. That is why, my lord, let the case come. I produce the case a short. Since he is behind the bar, since he is behind bar, let a short date be given. I produce the case and on factual aspects, only after producing the case I will be able to meet his my learned friend's submissions. Without taking instruction from the IO or factual aspect of the without going through the case, I may not be able to make my correct submissions. That is why I need some time. Let the case come. A short date may be given, my lord.
May I just respond? My learned specific, and what my learned just pointed out why they drag me into this, why make these imputations against me. I am a farmer by profession. I also do not want to divulge a lot of facts. In this case, and he has said that I have come on the first day, I have not come on the first day. This is an affidavit which was sworn on 13/3, and this affidavit was sworn produced before the magistrate. So I am quite aware of the fact. In fact, my televised interview is also there on record, where I have also stated that how this affair was caused. So it's not a question of me losing the effort. Coming here on the very first day, on 13/3 itself, affidavit was sworn. I went before the magistrate. I was quite aware of the fact that a person has been arrested. He is in jail, knowing that a bail application has been filed, so that is why he has come here. No need to, my lord, point fingers showing that there is some unholy nexus between me and the petitioner.
That's a statement, my lord. If somebody pressurized him, it was his duty to reveal the name of the police officer who has threatened him. And an FIR should have been lodged against that police officer. How a police officer can misuse his office, misuse his power to lodge an FIR, to threaten a person, a citizen, bona fide citizen, my lord, to lodge an FIR against somebody? And what interest has he got? What interest has that police officer got?
I'm just replying to what my learned friend is saying, not the first day, my lord. And this had happened, they already submitted, my lord. When this whole thing unraveled, my lord, was this whole, the person was arrested, my lord. Most of the ethics I know, many of the students and their guardians were approved. So I was also asked that whether my son was studying in this school or not. I was with my son studying there. He had also applied, he had also undergone that coaching, my lord. In this manner, my lord, this affair was lodged, my lord. And I have also fairly admitted that there was some misconception on my part. Now, because of my misconception, some person is in jail. So I have come forward and I have said that I am not opposing. Merit of the case, my lord, my learned senior friend has submitted, the learned PP will submit on the merit of the case. I cannot submit on the merit of the case. I'm only submitting that I have no objection because I have not wanted because of my misconception. That is what I'm saying.
My only reply that this is an unholy matter nexus because the first day informants directly came before your lordship on the motion stage. But in some cases, what we can see, in some cases on the first day itself, we can see the informant comes and objects. Then there is no objection from the public prosecutor that why he has come in the first day, how he come, how he is informed. There is no objection because in this case, because he has not objected to my bail, so this is an unholy nexus. But when the informant comes for an objection, there is no unholy nexus between the public prosecutor and the informant, my lord. Only when it comes for the no objection, then it is an unholy nexus between the petitioner and the informant.
The right is of participation.
But the right is the participation, my lord. How they can stop the participation? The Supreme Court in the judgment said from the every stage, in the first stage, is there any definition that he can't come in the first stage, cannot oppose and cannot argue or cannot support? To bail to appeal every stage, every day, he has a participatory right. That is the mandate of the Supreme Court. And he has said just because he's appeared in the first stage, it is an unholy nexus between me and him. Where from he is gathered? This is his presumption. But when the informant appears in the first day opposing the bail application, I have never seen these people are objecting that why he has come. Whether we have objected that this is an unholy nexus between the public prosecutor and the informant, never. We have never objected such kind of things, my lord, because we know our limitations, my lord. We cannot presume things just because somebody has come for objection. We cannot presume that there is a nexus between the public prosecutor has intimated somebody to object the bail application. Cannot be, my lord. We never did that kind of submission, my lord. And the custody, my lord, he was there. And apart from that, he said that is there necessity to in the affidavit. He can lodge the FIR, it is up to him. I cannot pressurize. This is his affidavit before the court. In the learned magistrate court, my lord. He has not. And in that case, my lord, this man publicly, in the public domain, in the newspaper, everywhere, he has categorically stated that he has been pressurized by the police. We have the video footage that he has been pressurized by the police everywhere, but nobody has taken the cognizance of the statement. Not even the state. Why the state is silent? That it is some police machinery is doing undue. It is the duty of the state. They are monitoring every aspect, every statement. Otherwise, if I make any statement, anything against, I'll pick up. Article kiba college of TV ulale arrest ho jay. Yat iman kini against the public servant. He has made an allegation in the public forum. There's no FIR by the state, and he said, "Why I have not lost the FIR?" You are a stick man. He's a farmer. I salute his courage, my lord. In spite of the fact that he was threatened by the police officer, still he had the courage to come before this. And he is saying that the case diary is required, but the case diary is required only for the factual aspect, my lord. What about the legal aspect, the other aspect? Forget about the informants, my lord, whether he comes before your lordship or not. But what about the illegal detention regarding the non-informing of that particular aspect? What about that submission, my lord? He has not addressed to that fact, my lord. He has simply said that just because of the informant has come, there's a holy nexus, they should not be granted bail. But what about the other legal aspect? Is it not the second FIR, my lord? when the first FIR is pending? Is not is that the information was concealed to your lordship, my lord, when the bail was granted in the second FIR? There's 2 affidavits pending. Is there any whisper about the pendency of this particular case? Why there's no mention about this particular case? Case is pending from 2014 itself. Why not whisper by not by the, I can understand the IO may not have the knowledge, but these affidavits were shown by who? That the Home and Political Department, my lord. They are silent about this aspect, my lord. And they are looking after the entire state, my lord. This is the parent department, and they are silent, considering the fact, so that they can arrest me again the moment I have granted bail. And that is what has exactly happened in this case. The moment I was granted bail, on the same day as I was picked up, he was waiting for 24/7, waiting for my arrest, my lord. So even then I can pray for the interim even bail. I'm not objecting to case diary in that case. If you want to go to it, but in that case, lordship kindly consider, as far as this judgment of the Honor of Gusai, my lord, interim should be granted, my lord, here itself, because every day's detention, my lord, today itself, if tomorrow nothing comes up, my every day detention will be an illegal detention. And this is the diversity of the justice, my lord. Nothing more than that, my lord. This is absolutely, my lord, lordship can see one after another FIR is going on against me, my lord. And the court has stayed the proceeding against me. Court has granted bail in all other cases, 2 cases, my lord, considering every aspect of this case, my lord. Then why my detention is necessary in this case, my lord? What purpose, my lord? Just to satisfy somebody, my lord?
One thing, Lord, so far ratio is concerned, Lord, your lordship know, ratios are in criminal jurisprudence, ratios are applied according to the facts and circumstances of the case. So far this case is concerned, Lord. So far allegations in the affair is concerned. But so it is so serious. But education has been converted into a commodity, Lord, which is the backbone of the society. Education. This has been turned to a, Lord.
There are 6 FIRs necessary, my lord.
Yes.
When there's a second FIR itself,
Yes,
it
I
is
understand,
elaborated.
I understand, Lord, relating to second affair. Apex Court has
We
said
are not here for
taken out
this political lecture, my lord. I want to address, my lord.
judgment.
Let him-
Apex Court has said
Let him
what is to be
object
done
to this.
in respect of second
Let him
affair.
submit
It-
regarding
it
the
does not
non-compliance
mean
of the
that second
information.
affair has to be thrown outright to the dustbin.
No, no.
It is to be used as
160 said, that is what my submission also.
This is the preliminary stage of investigation.
No,
Why?
my lord.
Why
Yes.
without raising the case that he should be released on
No,
bail?
no, regarding the, what about this, my lord? What about the which is not informed? This is on record, my lord. Why the court was concealed? That vital information. What about that, my lord? Let them submit on that. We are not only political lecture.
These are all matter of facts.
This
Whether
is on
informed or
record, my
not,
lord.
whether informed or not, these are matter of facts.
No, my lord. This is a
That-
matter of
whether
record.
in
How can
respect
it be a matter of fact, my lord?
whether in
Information.
respect of this affair.
This is an affidavit shown by the political additional secretary, and he has said this is a matter of fact.
Yes.
I am surprised, my lord. I'm flabbergasted. This can be a submission on an APP that this is a matter of fact. This is a matter of record, my lord. Absolutely they are silent about the fact, and this is what the Supreme Court says, that you cannot conceal when the bail application is pending. You are not supposed to. You are bound to. The wordings are very serious in that judgment, my lord. In both the judgment, you cannot conceal. This is what exactly has happened in this case. They have concealed the fact. Then why the concealment? So that they can arrest me. So that I cannot take the advantage legal recourse. I cannot come for the stay, or I cannot come for the anticipated bail. That is the intention. That intention is apparent on the face of the record. And he's saying this is a fact. The affidavit can be a fact. I have heard it for the first time in my life that in affidavit in order. I am saying about Mr. Das. I am saying about myself.
Affidavit is
I'm not
not
saying
only in
anything.
respect of facts, my lord.
My lord, I'm
Nothing
saying
else.
affidavit. No, sometimes affidavit is also fact, also knowledge. Also matter of records also. If you have gone through the affidavit in any type, if you have drafted an affidavit, you'll see that sometimes it's a knowledge, sometimes on record. There are 2 parts. So this is what? This is the affidavit filed by them. There's no, I'm simply saying that they have filed the affidavit. There's no mention. Why can't you admit that proposition, my lord? Can't be brave and admit that. Let us prevail the rule of law. We are not for anybody, my lord. We are just for the rule of law. Why you are standing here? Our duty. We are also officers of the court, my lord. We have also duty to prevail the rule of law. This is the rule of law, my lord. This is the judgment of the Supreme Court. We have to honor it. You address on the judgment that no, this is not applicable in this case. No, this is the facts. This is, my lord, I'm never surprised. This is the standard, my lord. Lordship kindly grant me the bail, my lord, either interim, my lord. Because if not disposed today, my lord.
I have objection to interim bail.
Okay.
I
Pass
understand
you.
any sort that, my lord. Your lordship.
Pass
Police the case then.
Acknowledgement. Highly obliged.